Okay, so I think we are all here. So thank you everyone for joining us on this 39 Essex webinar on state aid and procurement issues in this COVID-19 emergency. So my name is Deok Joo Rhee and I'm joined by my colleagues Kelly, Stricklin-Coutinho and Ben Tankel, who I think you'll be able to see on the screen just now. So we're going to present today on 3 topics. I can get my screen to work. So firstly, Kelly is going to kick off by addressing aid schemes and the Commission's temporary framework, and she'll look at both the framework itself as well as some of the UK schemes that have been approved. I will then go on to look at briefly the other ways of granting aid lawfully, that is without notification, and then really focus on what I call the social dimension to the traditional state aid analysis. And what I'd like to do is explore the potential for somehow incorporating the concerns that are informing aid decisions at the moment, and the potential for them to be addressed within the existing state aid regime. And then Ben is going to pick up on some procurement issues, considering in particular the changing market landscape and the way in which the procurement regime is evolving in response to the issues. So we're aiming to speak for about 45 minutes between us, and the aim is then to leave some time, perhaps 10-15 minutes for your questions. So those of you who've done this before will know that there is a Q&A facility at the bottom or top of your screen, and we will try and answer as many of your questions as possible, either in writing during this session or orally at the end of the session. Finally, the session is being recorded, so you don't need to take copious notes. The webinar will be available on our website with our slides, which will also be emailed out to you. So if I could then hand over to Kelly to kick off, and I will just come out of.
Thank you so much, Deok Joo. Let's see if I have successfully shared my slides. Yeah, looks like it. Okay, so let's start with the purpose of the temporary framework. So the Commission has set out in some detail the issues that are targeted by the framework. And there are 2 parts to the concerns that the Commission seeks to address. First, it recognises that this is a public health emergency and emphasises the very important social impact on citizens. But second, it recognises the global economic impact of the outbreak and the EU economic impact of the outbreak as well. Specifically as to what those economic impacts are, it refers to supply and demand shock, uncertainty in investment plans, and the consequential liquidity strains arising from the need to lock down parts of the EU. It also deals with the sectoral impacts of the outbreak, and specifically identifies the health, tourism, culture, retail and transport sectors. And of course, other sectors are going to be very significantly impacted. Taking culture quite broadly, for instance, one can't ignore the widespread cancellation of sporting events and the impact that that has had on the sector as well. And the framework also places significant emphasis on the role of state aid in ensuring a level playing field. And without wishing to take a very UK-centric outlook on the framework, I certainly read that with an eye on Brexit, and Deok Joo will be picking up on Brexit issues in more detail in a little bit. The Commission also emphasises their reasoning that there will be a faster recovery from the outbreak if the integrity of the internal market is preserved. Of course, there's already been some discussion around the volume of aid which member states are able to provide, and whether some of the larger member states may be in a position to help its undertakings more than others. And I think that's something which we're going to see increasingly becoming an issue under this framework. But turning back to the thrust of the framework, it provides guidance on 2 points. So what principles will be used to decide notifications made to the Commission, and then what types of measures are likely to be accepted on notification. And there is also specific, quite practical guidance on what a notification should contain. And if you're considering a measure which does require notification to the Commission, it's worth organising your thinking to follow that guidance. So the key points of the framework, well, the first is that the measures which are put forward are very much ones which have to be notified to the Commission. So notification is important, and in normal circumstances when measures are notified to the Commission, they can take some months to receive approval, and there is often, I suppose, an iterative process before that notification outcome is known. In the current context, the Commission is working very quickly indeed and has been approving aid schemes really in a matter of days. No doubt part of that is to do with notifications coming to them with structured information and following their notification guidance. But as I say, it's very unusual for the Commission to be dealing with notifications this quickly, and it's very unusual to have this very, very quick turnaround. It's also worth noting that the aid given under the framework has to be linked directly to the outlook, both in terms of the need for the measure and in terms of the remedy itself. There are certain measures which the Commission has said are likely to be approved. And looking at the detail of some of those, there is, of course, some detailed guidance as to how each of these work. But the measures which are likely to be approved are these. So where we have direct grants, tax advantages, limited advance payments for grants, and the limit is €800,000 at the moment. State guarantees for loans, subsidised interest rates on loans, and then guarantees and loans which are being channeled through credit and financial institutions, and then also short-term export credit insurance. Those were the initial raft of measures that were approved, and then subsequently some more measures have been introduced following discussion with member states and further approvals. So some of those include, for example, direct support for research and development, and that's particularly where the research and development is for material which helps the response to COVID-19, as well as investment aid products and facilities which concern the response to COVID-19. Also, tax and social security contributions have been referred to in the most recent version of the framework, and those are ones which may be deferred in certain circumstances. And the Commission has more recently added wage subsidies after more than one member state has now used direct subsidies for wages as part of their package of assistance. One example of that is Bulgaria, which has chosen to do it specifically for sectors such as retail and sports and so on. And of course, we have our own UK subsidies as well when it comes to wages. And the Commission has said that these are indications of what might be approved very quickly. But they've also said that they're going to consider alternative measures. So those alternative measures are ones which they are happy to look at and turn around as quickly as possible. But I think realistically, if one is expecting to get an alternative measure approved by the Commission, one would expect it to work within the bounds of the guidance that the Commission has given already as to the types of measures it's seeking to help with, and also as to the details as to how they're supposed to work. And in fact, between the original version of the framework and the amended version, approvals were given for measures which are in fact now part of the framework as it is. So turning to some of the UK measures, well, just a very short word now on some of those. You'll already be familiar with quite a few of them, I'm sure, so I shall keep it brief. The UK applied for an umbrella framework, which is worth about 50 billion, and largely those measures were focused on liquidity. So the main measures which did require state aid approval were the Coronavirus Business Interruption Loan Scheme, bit of a mouthful, known as CBILS, and of course the large business version of the same scheme. And we've also had selective grants approved in relation to very specific funds which are targeted at specific sectors. So the two that have been announced are first the Retail, Hospitality and Leisure Grant Fund, and then secondly the Small Business Grant Fund. And there are, of course, other measures which the UK has in place, and those are regarded as not selective and therefore not in breach of Article 107. We do understand that those measures have been discussed with the Commission, and therefore I wouldn't expect a likelihood of any challenge to the basis of those. No doubt most of you will be aware of the current discussion around how long the UK's coronavirus response and how long those measures can continue for. One key issue is the scale of employees who've been furloughed and how long the UK is going to be able to maintain that scale of wage subsidy. It's therefore worth thinking about what happens when the UK does choose to pull back on those measures. At that stage, one can see that there may still be a need for support in different industries and different sectors. And it's at that stage, and perhaps even as early as now, worth thinking about what measures you might wish to lobby for if you're in a position to do so once those wider measures are pulled back. And of course, it's also worth considering, if you are a local authority in particular, what opportunities the current circumstances present to you, particularly in terms of a local authority's commercialisation agenda and any regeneration plans it might have. The current circumstances in terms of commercial circumstances might be rather a different market to what we've been looking at so far in the past couple of years. But also the temporary framework does represent something of a relaxation of rules, and it may therefore present you with an opportunity to invest in a way that you may perhaps not have been able to do otherwise. So I think there is plenty of scope for both opportunities for local authorities and also for potential recipients of aid. So let's turn now to some of the actual decisions which have been taken. There have been many, we're looking at a range of decisions which cover many of the countries of the EU. And I thought it might be worth picking up some examples which are particularly striking. So some of the early decisions concern specifically loss of revenue from cancellation of events, because in the early period there were substantial events which were cancelled, and the concern was reimbursing those costs. What's quite interesting is that they seem to cover quite a range of things. So it's not necessarily just the loss of ticket sales, but it's the loss of revenues from across that particular event. So it might cover, let's take a sporting event, it might cover both ticket sales or perhaps the other match day revenues that you might take in. So that's quite broad. Sweden has a measure in that regard. There are other countries as well. We've also seen, very interestingly, some examples of individual aid, and I've put up on the slide the two obvious ones that are most in the public domain. So we've got France, which has given a direct subsidy to the Renault Group, and then Denmark has given subsidy to SAS, its airline. And one of the interesting things about that is that, of course, individual aid has always been somewhat controversial, particularly where we look at airlines, where the industries are all competing quite tightly. So those circumstances will no doubt be of wider interest across the EU. And then, of course, we have also the sector-based provisions. So some decisions have concerned specifically culture, cultural events and sports. And then we've also had some which concern specifically the retail sector. That's not to say that the decisions are likely only to be in those types or that range of decisions. Of course, we've had a whole raft of decisions which are generally about liquidity and maintaining cash flow and ensuring that businesses can tide themselves over. And I think there hasn't really been much of a slowing down of decisions in this area, so we can expect that those are going to keep up with the pace that we've had them so far. One of the things that's very important about the temporary framework and how it operates is that, in fact, if you think about it, the temporary framework itself requires notification and it requires specific activity. That activity is likely to be quite extensive in terms of liaising with central government if you're a local authority to get your notification in process and then getting the notification itself. The alternative, which is actually notified or sort of put forward by the Commission straight away in the framework document, is that actually we can use our usual principles to deal with state aid. in these circumstances. So turning now to what else is possible, the standard principles that we could be looking at will be all of our usual methods. We might be looking at using the market economy operator principle such that what you're doing doesn't amount to a breach of Article 107. It's also possible to use the general block exemption regulation, and the Commission has said that COVID-19 circumstances may well fit within the range of things which are appropriate for exemption under the GBER. And of course there are significant advantages to that, because if you're under either of those, then there is no need to notify at all. And you might find with some of those that there is a difference in reporting and monitoring obligations. Of course, with the GBER, you do have your standard reporting and monitoring obligations, but with MEOP, you would deal with that in the normal way you would, in terms of evidencing that you are acting on market terms, but you don't necessarily have the same reporting and monitoring obligations that you do formally under the temporary framework or under the GBER. And it's also possible, as noted by the Commission in its framework document, that you could notify under other circumstances like the rescue and restructuring guidelines. It's worth noting that there are also two separate bases on which aid might be looked at in these circumstances. So Article 107(2)(b), aid to make good damage caused by exceptional occurrences. Well, here the Commission has already accepted that the outbreak of COVID-19 is exceptional within the meaning of Article 107(2)(b). And also the Commission has taken decisions on the basis of Article 107(3)(b) that aid to remedy a serious disturbance in the economy of a member state is compatible in these circumstances. So both of those bases have been used as way of decisions under the framework. Moving on to the exemptions, it's probably worth mentioning that, of course, in the normal way, we can still use a de minimis exemption if it's relevant. And the general block exemption regulation will have a range of different parts of the regulation which may well be relevant. But then don't forget, there are also other principles that might be relevant in the present circumstances, like, for example, Sgei. Deok Joo is actually going to look at that in much more detail than I. So on that note, I am going to hand over now to Deok Joo.
Okay, thank you for bearing with me. You can probably tell this is my first webinar. So as I explained in the introduction, I am going to focus in particular on what I call the social dimension to the existing state aid regime. So in a way, I'd like to take a slightly longer term view. If you think about it, we are already in May and the outbreak first hit our radar in January. So I think it won't be pretty quickly, we'll be in the autumn, and if we know it, we'll be looking beyond the temporary framework if it's not extended. So I do think it is important to look further. So in terms of the current landscape, obviously the existing state aid rules apply until the end of this year, unless of course the transition period is extended. And importantly, the Commission and the Court of Justice will retain jurisdiction for 4 years after the end of the transition period. So that is something to be mindful of. The second point really is that when risk assessing for actions you may be taking now, it's helpful to have one eye on the draft state aid regulations which were laid before Parliament in January, and that sets out that in the event of a no-deal Brexit, there will be little change to the substantive state aid rules. So, so that is in a way the default backstop position at present. And the second point that may factor into any risk assessment that you carry out is really that given the EU's present fragility, and we read about that the whole time, they're likely to place a premium on flexibility. So the Commission is likely, in my view, to be prepared to be more flexible in the circumstances, and in particular to acknowledge the need for a greater degree of member state discretion. So Kelly's just explained already the Article 107 rubric, and so I won't dwell further on that, but leaving that to one side, one's really left with the twin rubric under 107.1 and the notion of state aid that that provision sets out. And one will see immediately that certain measures, generally applicable measures, will fall outside the notion of aid. So much of the EU's current aid scheme will not, in fact, need to be considered under the state aid regime. And the second limb of the rubric under the treaty is the notion of Sgei, services of general economic interest, which one sees in Article 106.2 of the treaty. And that really encapsulates the public interest dimension to the state aid regime. And I think it's probably fair to say that looking at the structure of the treaties, the public interest dimension appears really to be bolted on almost as an afterthought, and really 107 is the primary provision, and it really denotes the primacy of single market considerations which permeate this field, and certainly that imbalance or lack of symmetry between those two elements has certainly characterized much of the Commission's thinking, at least in the past. So aid without notification, we've already seen the possible routes, and I mentioned there the de minimis regimes, and obviously they're twin separate regimes for general aid as well as for Sgei. Existing aid schemes, of course, do not need to be notified. The GBER, notably, this doesn't cover exceptional occurrences, notwithstanding that it can be potentially useful, as Kelly has explained. And finally, the Sgei block exemption. So given the fact that this is in the treaty, I think it's important to pause and look at Sgei in particular, and to understand what this really means. It's not defined at treaty level, but one sees a definition issued by the Commission in its 2012 communication. And the key part to draw out here is that really these arise only in respect of services that are not and cannot be provided by the market in the way that one would expect and hope. So it's really a market-centric analysis. It's if the market cannot deliver this in a satisfactory way, then you're potentially in the territory of Sgei. And so these are typically delivered under what are called public service obligations, which need to be carefully defined. And examples are infrastructure costs relating to broadband and transport, which everyone will be familiar with. And this builds very much on the Outmark decision, which sets out certain criteria which need to be fulfilled. So two instruments dealing with Sgei. We have the block exemption, under which a notification is not required. And there's the framework for larger, more complex cases where notification is required. As Kelly mentioned, the Sgei may often be a first port of call after the de minimis regulations if you're looking very much at provision of assistance in respect of public services. But as anyone who's had to deal with Sgei will know, these can be quite technical and difficult to apply, and it's also not entirely predictable how the Commission will consider one aid package compared to another. And so on this slide, I've just referenced a couple of decisions which you may want to look up, which which illustrates the complexity really of the analysis that is needed. So it's with all of that in mind that really what I want to focus on are the fundamental constituent elements of state aid. Does the measure in fact amount to aid? And we're all familiar with the constituent elements. Is there an undertaking? Is a selective advantage conferred? The market economy principle will also play a part, and is there an effect on interstate trade? But what I really want to look at is, in respect of each of these elements, the possibility of actually building in the social dimension, so building in the very concerns that you might be seeking to address through the provision of aid because of this COVID emergency. And really the treaty basis for this approach or the justification comes from the changes introduced by the Lisbon Treaty. And so at the outset, I mentioned very much that the treaty focuses very much on the single market provisions, and Sgei plays quite a secondary role. But really one sees in the Lisbon Treaty the signs of something new. And so there's reference in Article 3 of the TEU to the EU being a highly competitive yet social market economy. And there's reference to sustainable development and the need to combat social exclusion and discrimination. And similarly in Article 9 TFEU, various goals which are listed. High level of employment, adequate social protection, the fight against social exclusion, protection of human health. So again, very much a different order of considerations to the standard level playing field type considerations you see in the state aid and procurement fields. So I want now to just quickly look at each of these elements and just see what the scope is for building in this social dimension. So the orthodox position in relation to the identification of an undertaking is, firstly, does the undertaking engage in an economic activity? And here, surprisingly, perhaps, the answer doesn't depend on whether the aid recipient is profit-making or not, but it really depends on external considerations, whether there is a market for the services, whether there are competitors who would be willing and wanting to provide these services themselves. So unlike in the procurement context, where in-house provision will take you outside the procurement regime because you would then fall within the self-supply or tackle the exemption, self-supply is not a basis which would take you outside the state aid regime. So even if you're supplying to an in-house provider, if there are other competitors who would be wanting to make that provision, then that in-house provider, whether they're profit-making or not, is an undertaking. So this is a very broad approach to state aid. But there are indications of a different approach, and I think on these next two slides I mentioned two cases. Firstly, Spezzino. So this was not, in fact, a state aid case. It was actually a case about the direct award of emergency ambulance services to a voluntary body without procurement, without a procurement exercise, despite there being a market for those services and commercial providers willing and wanting to provide these services. And so in considering whether there was a breach of the single market principles, the court in this case said account must be taken of the fact that the health and life of humans rank foremost among the assets or interests protected by the treaty. And it is for the member states which have a discretion in the matter to decide on the degree of protection which they wish to afford to public health and on the way in which that degree of protection is to be achieved. So that is a different approach and one which certainly goes against or cuts across the orthodox position which I outlined in my previous slide. And some commentators have suggested that in the health sphere, there is a different approach in the state aid and related arenas. So that's Spezzino. And the second case, which I've called TenderNet, although it may not actually be the official name of the case, but I've given the case number. There, the question was whether there was an economic activity when the Netherlands government introduced an e-platform, which was called TenderNet, to implement the new directives on public procurement. So this was an in-house platform put together by the relevant ministry in the Netherlands. And here, when concluding that there was no economic activity despite the existence of competitors, the court gave quite an interesting ruling, and it's paragraph 68, which I've highlighted in particular. And the parts highlighted, to my mind, show that really what the court has in mind is a priori or in principle distinction between what ought properly to fall within the public sphere and what can simply be looked at from a single market perspective. So simply because the state hadn't previously occupied the space does not mean that this is an economic activity occupied by commercial providers. And it used the phrase an inherent economic activity, which again points to something normative or an in principle notion of public services. So I think those are two interesting cases if one's wanting really to explore that particular potential. So really just to recap at this stage and draw together what we've covered so far, taking the example of PPE, which I know will be an issue close to everyone's heart. So there are three different possibilities that we've touched on so far. So firstly, as Kelly's mentioned already, within the temporary framework, part of what has been authorised, both, I'm not sure if it's in the UK aid package, but it's certainly in a number of other aid packages by other member states, aid to incentivise the production of certain goods designed to combat the health epidemic. So given the shortage of PPE, the idea is to incentivise companies to start producing these markets to stimulate the market to increase its output. And interestingly, this will be at pre-outbreak market prices. So, and then the second option is really to attempt to push this within the services of general economic interest heading. So there we've seen that where the market cannot deliver, then, and the service is in the public interest, then you're in the territory of the Sgei exemption. But the questions really here are, should PPE be dependent on market forces? And in any event, the market normally can deliver these products, but in an emergency, due to increased demand, it finds that it suddenly can't. And so is this really a situation where one would need to go away and craft public service obligations and go through those steps? And then the final option, which is the option I've just been exploring, is looking at whether this is in fact aid where, despite there being a market for PPE and competitors, a member state may choose to either make PPE in-house or perhaps even to procure it, but at cost price. And I think each of these options really point to a very different approach to public services and to the market. The temporary framework, in my view, really kind of underscores the market approach by looking at this as an instance of market failure. But really, if one's looking at this from a public governance point of view, shouldn't there be something slightly more inbuilt within the fabric of the state aid regime, which is capable of addressing this kind of problem. So then looking at selectivity, as Kelly's mentioned, certain aspects of the UK scheme simply don't meet the definition of aid because they are of general application. There's a question mark in relation to the business rates holiday for retail, hospitality and leisure. And the government hasn't explained, but simply asserts that this is not state aid, which then leads me to consider the social dimension to this element of the state aid analysis and cases underlining the importance of the objectives of the aid measure when determining whether a measure is selective or not. And I mentioned two particular cases which illustrate this approach. So the first case, Paint Graphos, the court found that the factual and legal situation of workers and producers of cooperatives in Italy was quite different from ordinary capital companies in the light of the objective pursued by the corporation tax regime. Therefore, the application of a special regime of corporate tax exemptions for these cooperatives did not amount to state aid. So if your purpose is really, the purpose really delimits the beneficiaries, then that is a basis on which one can say the measure is not selective and so take you outside the state aid regime. And a similar approach was adopted in the second case that I mentioned in relation to a tax on large commercial establishments. Finally, or no, thirdly, the market economy operator principle, one sees this deployed in the context of determining whether aid confers an advantage on the recipient, and a more socially oriented interpretation of the principle can be seen in Corsica ferries, which isn't a particularly recent case, but one sees that paragraph 82, a reference to those precise words, the social market economy that we've seen introduced by the Lisbon Treaty. So in particular, the challenges relating to social responsibility and the entrepreneurial context are in fact capable of having a major impact on the specific decisions and strategic planning of a reasonable private investor. And then last but not least, effect on trade. And historically, this is an element that I normally gloss over because attempting to rely solely on this as a basis for saying this isn't aid is always quite risky in my view. But what one is beginning to see is an increased willingness on the part of the Commission to recognise that certain measures will have a purely local impact and so are unlikely to attract customers or investment from other member states. And in the present context, I've seen that in relation to the Retail, Hospitality and Leisure Grant Fund, a concern's been expressed on behalf of charities that the state aid limit is likely to limit their ability to claim to approximately 30 shops. And so they are exploring the possibility of lobbying the government with a view to relying on this lack of effect on trade to somehow get round that state aid limit. So in conclusion, my key points really are start from the beginning. Is this aid? Adopt a layered approach to your risk assessment, looking at aid, the block exemptions, in particular the Sgei block exemption. And I think also it'll be interesting to look at Commission enforcement decisions in respect of COVID-19 assistance going forward. And it will be interesting to see if they do take quite a robust approach to non-compliance or whether one will be able to detect a degree of leniency or flexibility. And a question perhaps for the future is whether the CMA under the post-Brexit regime will take a more lenient view. So So those are all my slides, and I am now going to hand over to Ben.
Hello everyone, let me just work out how I can share my PowerPoint slides with you. Okay. Good. Well, hello everybody. We've got one question in so far, so feel free to, 2 questions, so feel free to ask more if anything, any burning issues have come up. I'm going to be talking largely about procurement, how that's changed in the world of COVID-19. We start with an odd one out round. Answers on the Q&A form. There's no prizes, just your own sense of self-worth, and I'll give the answer at the end. And your topics for the odd one out round are Virgin Trains, makers of a cleverly engineered set of airflow-based technology, a food delivery service, and the cast of a 1990s TV sitcom. So answers in the Q&A, and I'll reveal, for those that don't get it, the solution at the end. Now, 39 Essex Street's already done a procurement webinar, and I'm not going to cover the ground that was covered in that forum. Have a look at our website, 39essex.com, and we've got a special section for webinars, and you should find there the webinar that our colleague Parashil Patel did on procurement, and it gets into some of the more technical legal detail. But for those who haven't yet watched that webinar, I'm just going to do a very brief introduction to some of the ways in which the procurement world has changed in the coronavirus environment. There are 2 key pieces of guidance which, if you work in procurement, you need to look at. If you haven't already, they're both quite short, but they're both very good. First is the public procurement policy note produced by the UK government, and the second is the EU Commission communication, and its full title is there. The key message is that contracting authorities should be aware of the scope for flexibility that already exists within the procurement rules. And basically, the answer is that contracting authorities can ultimately resort to making direct awards if necessary in cases of extreme urgency. That's Regulation 32(2)(c) of the Public Contract Regulations 2015. So there is a built-in exemption within the regulations as they already stand, which is there to be used if the coronavirus epidemic is making procurement strategies, conventional procurement strategies, too difficult to operate. So that's the quote from the regulation. And this relates specifically to the negotiated procedure without prior publication. I'll come on to that in a little bit more detail in a moment. But first, I just want to talk about what exactly exceptional urgency means. There are derived from Regulation 32(2)(c) these 4 requirements. They are cumulative. Every single one of them needs to be satisfied in order for the exemption to apply. There need to be genuine reasons for the extreme urgency. So, for example, public health risks or loss of existing provision at short notice. And important to emphasize here that although what grabs the headlines are the need to procure PPE or ventilators, 2 examples which we will come on to, there are many other impacts of the coronavirus epidemic on supplies to contracting authorities. So, for example, if you have a supplier which is out of operation because all of its staff are ill or on furlough, or it can't keep up with an explosion in demand, then those are also matters of extreme urgency arising out of the coronavirus epidemic. It has to be impossible to comply with the usual timescales. One of the major problems with operating a conventional system of procurement during a pandemic is the long timescales, mandatory timescales that are built in to the regulations. Now, those can be accelerated in certain circumstances, but even the accelerated timescales have a minimum number of days for which the procurement exercise needs to be run. So sometimes it's just not going to be quick enough to deal with the crisis which is immediately at hand. Third, the consequences of the situation have to be so novel as to be unpredictable. You couldn't reasonably have predicted them. And fourth, the situation isn't attributable to the contracting authority. So the reasons for urgency cannot be a problem of the contracting authority's own making. Now, I'm going to focus on the last two of those, and I'm going to do so in the context of the procurement of ventilators from the Dyson company. So the background is, on the 16th of April, the government suddenly woke up to the fact that it didn't have enough ventilators and it would need to procure more. It probably through a negotiated procedure without prior publication, went to James Dyson, or James Dyson came to the government perhaps, and they agreed to buy, I think, 10,000, 5,000 ventilators from Mr. Dyson. Questions. Was it not predictable that the government would need ventilators at a much earlier stage? After all, the WHO declared a pandemic on the 30th of January 2020, and it was widely reported from January, February onwards that there was at least a foreseeable chance that demand for ventilators in the NHS would exceed our existing supplies. That's question number one. Question number two was the urgency of the government's own making. You will all recall that the government's policy for the first few weeks of the pandemic was that the population should acquire herd immunity. That policy then changed, but for as long as the government was pursuing a policy of herd immunity, it could legitimately say that it wasn't necessary for it to acquire additional ventilators because it wasn't necessarily going to be treating. Now, that's a political decision. It's one which changed, but one might ask, why should the fact that it was a political decision necessarily insulate the government from challenge to its award of a contract to James Dyson? Because these things ought to be objective. One can look at the government, say it made the wrong call, and it should have started to acquire ventilators earlier. Now, I emphasize, I don't think anyone is realistically expecting ordinary manufacturers of ventilators to take this challenge on, not least because the optics of such a challenge would be fairly difficult to justify. But I'm just using this as a lens for examining the sorts of questions which might come up for you in deciding whether you or your clients will be able to take advantage of the exemptions which exist. And these are the sorts of, I'm not going to try and answer these questions now, but these are the sorts of questions which it's important, I think, for you to be asking yourselves when giving advice in this area. And then finally, the question of strict necessity. So one of the rules in Regulation 32(2)(c) was, as insofar as it is strictly necessary, the exemption is available, or the ability to use the flexibility within the regime is available. Now, the thing about the Dyson company is, again, as we all know, it's not known as a producer of ventilators. It had to design them all from scratch, and it had to design them all from scratch, and not only that, but Dyson would have had to obtain regulatory approval for the ventilators which it designed. So there was no question that Mr. Dyson was going to be able to produce all of these documents, all of these ventilators in time for the urgent need. So it's hard to justify in retrospect that that particular contract, for that particular contract, it was strictly necessary to go to Mr. Dyson on one of these exempted, more flexible bases, because he was never going to be able to meet the immediate need because of the need for regulatory approval, which he didn't yet have. Now, moving on from there, I just want to go through some more what I hope are practical tips for you if this particular question arises. First of all, the Commission, the European Commission, in its guidance note, which I referred to on an earlier slide, specifically says that the consequences of COVID-19 are extreme and unforeseeable, or at least it can't reasonably be doubted that they're extreme and unforeseeable, so far as the immediate needs of hospitals and health institutions are concerned. Now, that applies only to hospitals and health institutions, but it is at least a helpful steer from the Commission, an authority on the subject, from the Commission, that the coronavirus epidemic is good reason for invoking Regulation 32(2)(c) in appropriate circumstances. Second, it's important to work your way up the scale, meaning the first thing to do is to see whether there are existing conventional procurement strategies which can work in this environment. So, for example, dynamic purchasing systems or framework agreements, all of which are capable of dealing with the kinds of changes in demand and unpredictability that might come about as a result of this pandemic. If that's not good enough, then look at accelerated procedures, so shortening the timescales. But even those, as I say, have a minimal requirement of time for which the exercise needs to be open. So if that's not good enough, then one should turn to the negotiated procedure without prior publication. And only if that doesn't work, then it's time to consider the making of a direct award. But the expectation is that you will work your way up the scale from the bottom up, ruling out the less flexible exemptions until you get ultimately to a direct award in appropriate cases. Urgency is not limited to public health, the point I already made. It could also be connected with suppliers not being able to meet demand, or your main supplier being on furlough or ill or whatever. There are no minimum standards for the negotiated procedure without prior publication or for the making of a direct award. And that comes very strongly as a message from the Commission's guidance document. And that means you don't need to, not as a result of EU law at least, but you don't need to go out, for example, to 3 bidders in order to work out who's the best bidder. There's no particular timescales, and it emphasises that these procurement exercises can be turned around within days or even hours. Fifth, it's important to take a phased approach. We're all panicking at the moment, or perhaps we're past the moment of panic, but there are immediate needs and medium-term needs and long-term needs. It should only be necessary to use the most flexible type of exemption to meet the immediate needs. So even though, for example, the UK government might need to keep ventilators being produced for the next 8 months, the flexible type of procurement exercise might only be needed to produce ventilators for the next 2 months, and more conventional procurement exercises can be used for the long tail thereafter. So again, these are only to be used in exceptional cases. Work your way up and also use the flexibilities in the most limited way that is realistically possible. Benefit of hindsight is a great thing, but you don't need to worry about it. Questions of whether something was predictable or necessary at the time are only ever going to be judged by a court on the basis of the information that you had or reasonably had in front of you at the time that you made your decision. Very important to evidence your reasoning as to why you've used flexibilities for 2 reasons. One is because it ensures good governance, and second of all, in the event of any challenge. So that is evidence of your reasoning for awarding a contract to a particular supplier, but it is also evidence of your reasoning for using the flexibilities that you have. So explaining why you've made your way up the scale, explaining why you've used a phased approach or haven't used a phased approach, or whatever it may be. And finally, this will all return to normal. There is still a hinterland of normal procurement processes. There will be many types of contract that you will still need to award according to ordinary procurement processes even now, because they're not necessarily affected by the coronavirus pandemic, or not impacted to the level necessary to justify these exemptions. And as we begin to emerge from the pandemic, there will be difficult judgment calls as to whether it is still affecting us in the ways which require recourse to these sorts of more flexible processes within the procurement regime. This isn't a blanket exemption to be used just because there is coronavirus around, and it's certainly not going to be acceptable just to use coronavirus as an excuse for using procurement regime flexibilities where it was still possible, notwithstanding the epidemic, to carry out a normal procurement exercise. Now, I want to just say a few things about what it means to be carrying out procurement in a world of scarce resources and incredibly intense competition for the limited resources that do exist. PPE being the most obvious example of this at the moment. And I don't know how many of you advise NHS England or other NHS bodies, but limited supply and extra competition for those supplies might well be a question which comes up in different ways for different types of contracting authority. So again, by reference to that Commission guidance, the Commission endorses what it calls active buying techniques. So that means, for example, generating your own leads by making phone calls, by emailing suppliers proactively, and by relying on agents who might have better contacts in the market, by sending out delegates around this country or to other countries, all of which might have been anathema to the traditionally arm's length approach to procurement exercises. The Commission also endorses the use of urgent procurement to spur market innovation and matchmaking, so real active interventions in the market. But what are some of the problems associated with scarce resources, and how do you need to factor these in as legal advisors? Well, one of the major problems is an excessive number of leads. Open calls for procurement can lead to a flood of leads which are difficult to sift or to evaluate. And that can't be easily done within conventional procurement processes. And that could be a further reason why it's strictly necessary to depart from conventional procurement processes in a particular case. In a very real way, that's what's occurred possibly with home testing kits, which the UK government has purchased. And the UK government purchased $20 million worth of home testing coronavirus kits from a Chinese medical company. And there are reports of the medical companies in China being extremely aggressive and demanding, for example, yes/no answers within 24 hours and full payment upfront. That's not the kind of market environment which public authorities are typically well set up to deal with, and mistakes will happen. But it's the sort of thing which I think needs to be at the forefront of our minds as legal advisors or as procurement officials in making these sorts of decisions. Those $20 million worth of home testing kits turned out not to work. And the battles have already begun with the Chinese medical companies saying that the UK government was making exaggerated claims as to how useful or effective they would be. So that's, I think, a good insight into the sorts of arguments which you may be able to begin to expect arising once we've made our way out of some of these woods. The caseloads of PPE gowns that don't meet UK standards is another good example of this particular problem. I think there also appear to be problems with validating or vetting new startup companies promising all sorts of exciting new technologies, particularly in the medical and PPE space, have been in other areas as well. And you can imagine how operationally difficult it might be to be able to start to validate or evaluate some of these companies which are cropping up. They might have no proven track record, there's intense competition, very short turnaround times, they might be in other countries. It might be very difficult for your client or for a contracting authority to send out delegates to other countries to do proper background checks or that proper due diligence in the way that they ordinarily would. You might be asked to pay money up front to people with limited credit history. And these are all sorts of very, very difficult questions which arise in the world of procurement. But when there are such scarce resources and it is so heavily weighed in favour of sellers. And finally, I just want to mention the importance of avoiding flawed decisions. The procurement regime is not there to help you to make meritorious decisions, decisions which are right on the merits. It is there largely to avoid some of the more or less corrupt practices which plague commercial contracts in the past. So procurement does still work, and there are still values which can be taken out of procurement and applied in our context. So the need for transparency, the need to avoid conflicts of interest, the need to do whatever due diligence it remains possible to do, even if a full-blown procurement process isn't being followed. And I think that finally brings us on to the answers to our Q&A. Sorry, I don't think I can check the Q&A at the same time I've got my screen up, but of course the odd one out was Virgin Trains. It was the only firm that bid for something it had expertise in. So if I just go back to our odd one out round, Dyson bid for something when it had no expertise in making ventilators. Joanna Lumley was behind one of the design companies which bid to work on the Garden project, as well as being a major proponent of the Garden Bridge over the Thames project. And then finally, you'll all remember the classic story of Seabourn Ferries, who used the terms and conditions of a food delivery company on its website, which purported to be the website of a ferry service, even though it had no ferries. So I am very grateful for you all for listening to me so kindly. I will share my screen with everybody else now, and I can see we've had some questions coming in.
So, Kelly, did you want to kick off with the question about UK schemes?
Yeah, absolutely. So the question is whether the umbrella scheme that we've seen is the last that we're expecting in terms of UK EU approved state aid schemes. Nothing else has been announced. So what I say now is pretty much just sort of crystal ball gazing. But I think what is likely is that there'll be a withdrawal of some of the current measures. And I think that that withdrawal is likely to take place in circumstances where further assistance will still be needed. And if that does happen, I think we're going to start to see sector-specific aid. So we've already seen, for example, the 16 million loan to RFL. It's an emergency loan and it's to the entire league. And I predict that there might well be more measures of that type. It's not clear to me whether, for example, that's going to be the type of measure which doesn't need to be notified to the Commission, or whether it's something which needs to be formally approved under the notification scheme. And of course, I think it's very dependent on who lobbies for that kind of measure. It may just be that certain industries do, and that's what they get. And finally, I think there are some non-legal considerations around that, because, of course, we've already seen the government refuse to bail out airlines when they've asked. And I think there's also been some discussion in the public domain around, you know, what kind of companies are accepting furlough payments. So there are some wider issues that aren't just legal. And then finally, there are some aid schemes where the country has said it's not going to pay out on the aid scheme in certain circumstances. So, for example, I think both Poland and Denmark, if I recall correctly, have said that they will give aid, but they will not give aid to companies which have their bases in tax havens or have something to do within their group with a tax haven. So I think there is the potential for some further schemes, but how those schemes look is up for discussion.
So Kelly, whilst you're talking, there was just a new question in relation to accumulation.
Yeah.
I think the answer to that is yes, but
yeah, there are specific bits of the temporary framework which say that accumulation is permitted, and there are some reasonably detailed bits of guidance as to how you do it. But yes, accumulation is generally permitted.
Great. So I think the next question, there's a question about the effect of on trade criterion and reference to a Commission decision about public support for the swimming pool in Dawston, and the decision there was that it didn't affect trade because it served only a local population. The question is the size, as I understand it, is the size of the undertaking a relevant consideration when applying this criterion? So, I mean, my view on that is that really one has to look at it not only in terms of who the potential customers are. So where you're talking about a swimming pool, it's unlikely that someone's going to travel across Europe to come and use the pool unless incidentally they happen to be on holiday, but it's not a customer in an ordinary sense. So that's one aspect. And the second aspect is really to consider the investment potential in the business. Is this a business that is likely to be owned or part owned by EU entities? So really, I think it's not so much the size of the entity that is relevant, although I appreciate that it may, in certain extreme cases, be a factor. But just to illustrate that point, I think the Commission has held, for example, in relation to a local hospital, and there the size of the hospital, I assume, was relatively sizable, but even a local hospital was unlikely to have customers from across the EU. So I think one has to be a little bit careful in adopting indicators in that way, and one has to look at the situation in the round. So, okay, there's Ben, there are a couple of questions in relation to procurement in your presentation. Yeah. Have you had a chance to look at them?
I have. So someone has asked whether I was suggesting, I think they're asking whether I was suggesting that a direct award can be used even if there is no justification for invoking Regulation 32. I think that was the question. No, the one can only get, if I wasn't clear, one can only get to using a direct award if you have exhausted the possibilities of using Regulation 32. So that will be in a case where even the very flexible negotiated procedure without prior publication isn't going to satisfy the urgent need which you have as a contracting authority. And if I can just read out from the EU Commission's communication about all of this, and it's on, for reference, it's on the first page of that document, and I'll see if I can send you the questionnaire, a link to it in the Q&A box. But it says this, the bottom of the first page, should those flexibilities not be sufficient, a negotiated procedure without publication can be envisaged, and then eventually even a direct award to a pre-selected economic operator could be allowed, provided the latter is the only one able to deliver the required supplies within the technical and time constraints imposed by the extreme urgency. So that will be your justification. No other procedure will work, and the particular economic operator which has been pre-selected is the only one able to deliver the required supplies within the technical and time constraints imposed by the extreme urgency. So I hope that I've answered your question in the manner that you asked it. And I think there was another question, which is whether I have considered the way in which the government's PPN works in relation to concessions. So I think this might be, for example, a bus service or something of that nature, which receives a subsidy from a local authority, but isn't running a bus service at the moment or is running a reduced schedule. Can it still ask the local authority for the money under the contract? Now, I don't think that there's anything in, there's two PPNs. There's PPN 19 of 2020 and PPN 20 of 2020. The general one is PPN 19 of 2020, and I don't think there is anything in that PPN which relates specifically to the question of concessions. I haven't, have to say, applied my mind to the question of whether there is anything in procurement law more generally which applies to that issue. PPN 20 of 2020 relates to the procurement and construction contracts, right? And what that says, and it's a similar issue, where, for example, that construction and infrastructure project can't carry on at the same rate as a result of the coronavirus epidemic, then contracting authorities should continue to, or it's lawful for them to grant relief where that's necessary, specifically in order to prevent the supplier, the construction company, from going under. Clearly there's good public policy reasons for that. It would be a disaster and much more expensive to lose a contractor halfway through a project. Now that relates, as I say, only to construction projects. It may be that similar logic and good policy reasons apply to a concession contract, but certainly don't take this as legal advice, because I haven't, as I say, I haven't thought through the legal implications of that as a matter of procurement law, although on public policy grounds, good administration grounds, it may make sense.
Thanks, Ben. So there was also a question, if I can read out, where a council is being asked to pay for a school bus route that is not being used so that the bus company does not go out of business, is it the council that must decide if they give it as a grant, or, as in our case, I think the government are asking the council to recover the money later, whilst at the same time being required to check that aid is not being given by another council? So again, please don't take this as advice, but more an explanation of what I think the relevant principles might be based on these facts. I think the first immediate question is really, how much are you talking about here, and can you make use of the de minimis exemption, for example, and that would then save you a lot of pain by going through all the, jumping through all the hoops. Is it, and then secondly, what does your contract with the bus company actually say about these types of situations? And is there, say, for example, a possibility of renegotiating the contract so that cash flow issues are addressed without giving them more money overall? And obviously you will need to then consider still the state aid rubric as to whether that is a benefit, but instinctively my view is that you may be able to get away with that if it's simply a question of timing of payments. Otherwise, then if you're in the territory of the temporary scheme, then it's simply a question of applying that rubric, and whether or not another council is giving aid at the same time. And that is something that you will need to consider on any scenarios, even if you're within the de minimis regulation in principle. For the purposes of satisfying the non-accumulation provisions in the de minimis regime, you will still need to inquire as to whether aid is being given by other authorities, and that is because for the purposes of EU state aid control, it's the unitary concept of the state, so it doesn't matter which organ or organs of the state is giving the aid, it's the cumulative aid that you'll need to consider. I think there's a related question about contract variation. I don't know whether, Ben, you had some thoughts on that. I think it's mixed procurement and state aid questions. I'm happy to.
I'm thinking about it. The question is, or part of the question is, again, on the issue of relief that a contracting authority may need to give to a contractor in order to help them through these hard times. To the extent that that is affected as a variation under Regulation 72 of the public contract regulations, and what's a reasonable duration for that? So can the additional relief remain for the lifetime of the contract, or should it be limited to the lifetime of the pandemic or any consequences which follow? Again, not a question. I don't think I would want to answer that fully off the top of my head, and especially not without knowledge of the facts. It sounds like this questioner has a case, and I imagine the facts are involved. Everything else I have read in this area suggests that any exceptions, exemptions, variations which are made need to be very closely tied to the coronavirus epidemic. Just superficially, I struggle to see how, for example, it could be justifiable to vary a contract because of the coronavirus epidemic and then allow that to run for the whole of the rest of the contract, which could be for many years. I don't know how in practice, having not thought about it, how you would keep operationally that variation, that relief under review as time goes on. But I think I would be surprised if the answer were that the variation is a one-off thing and then continues for the whole of the life of the contract. You've also asked whether the variation would need to be published in the OJEU, don't know. You've also asked how the best value proposition would balance against the transparency duty. Again, I'm not going to even try to answer that off the top of my head in this context, but you sound like you have the right questions in mind.
Thank you, Ben. I think the only thing that I would add in terms of the state aid angle is that obviously procurement satisfying procurement rules doesn't automatically mean you satisfy the state aid rules. So you will need to conduct an analysis under both criteria, both regimes. So yes, state aid would need to be considered, but I think it does tie into the justification and the duration issues that Ben has touched upon. In terms of publication, I don't know the definitive answer, but my guess is that if this amounts to the award of a new contract, then obviously this would need to be published, but anything short of that, I'm not sure you would be under an obligation, unless of course you wanted to publish a VEET notice. That's a separate question, really. Kelly, was there anything else you wanted to?
There's quite an interesting question on business rates relief.
Yeah. Oh, yes. Yeah.
Which I think is probably worth addressing. So the question is there any understanding of the basis on which business rate relief is not considered to be state aid? And then the follow-up question is, if authorities exercise discretion within the guidelines, could that bring matters back into the state aid regime? I mean, on the first part, business rate relief is given in relation to specific sectors, and it seems to me at least possible that that is a selective application on the basis it's a derogation from the general regime, but I presume it's been justified on the basis that it's being given to the entirety of the sector or something like that. But I think Deok Joo, you alluded earlier to the fact that there is a bit less reasoning than one might like as to why some of these provisions are or aren't notifiable. But on the second point, there's something quite interesting around, I happen to have looked at the ones applying to retail, hospitality and sports, and any dispute that you have as to whether it applies to you is one that you must take up with your local authority. And it seems to me that the guidance as to what falls within the scope of that particular relief is not completely clear or well defined. So I can see the potential for some discretion to be applied there and for that discretion to be challenged. Did you have any thoughts on that, Deok Joo?
I think in relation to the first part of the question, I mean, that's a question that I had as well, and I was trying to fit it within each of the elements, and the only thing that I could possibly come up with was selectivity, on the basis that even though it does appear to be selective, if you're looking at the purpose or the objective underlying the measure, then from that perspective it at least covers all the obvious categories of businesses who would need or merit this type of relief. And I refer to a couple of cases, the Paint Graphos and the Anged cases, which look at this type of reasoning. So yeah, that was the only thing I could come up with. So is that, I think from my perspective, that was all I could spot.
Kelly, Deok Joo, questions also come through on email. I don't know if either of you are able to check. It looked like a state aid special, so not my area. Okay,
so multiple screens going on here. Oh gosh, it looks like quite a long one. I think that's the one I've addressed already, I think.
Okay.
Yeah.
Yes.
And effect on interstate trade. I mean, if you feel that we haven't answered your questions fully, then please, feel free to contact us, or if there's anything else that that comes to mind, then I think we've all given our email addresses. They can be readily found on the website. So we're all happy to be contacted. But given the time, which is, I'm sorry to say, 3:30, then I think we should conclude there, unless anyone else wants to say anything else. Kelly, Ben?
Fine, thank you very much.
Okay, well, can I just say thank you then on behalf of all of us, and I hope you found this useful, and yeah, look forward to speaking again sometime. Thanks very much.